I'm waiting for the recording people to tell me I can start. Okay, I can start. Thank you very much. Good evening, everyone, and welcome to the 28th Annual Silha Lecture. My name is Jane Kirtley. I'm the director of the Silha Center for the Study of Media Ethics and Law, and I'm based at the University of Minnesota School of Journalism and Mass Communication. We're thrilled to see so many of you here tonight. The Silha Lecture is the signature event for the Silha Center. In the past 27 years, our distinguished lecturers have included scholars, practitioners in law and journalism, advocates, cartoonists, and ombudsmen. They've all come to Minnesota to share their views on important and timely topics, including privacy, national security, censorship, and media ethics, from a variety of viewpoints across the ideological spectrum. Whatever their differences, they've all shared a deep and abiding commitment to freedom of speech and of the press. The Silha Lectures would not have been possible without the generous support of the late Otto Silha and his wife, Helen. Helen is here with us tonight together with her family, and I'd like to ask you to join me in thanking them for their commitment to the study of media ethics and law. Thank you. Thank you. I'd also like to take a moment to note the passing of Donald M. Gilmore, who was the founding director of the Silha Center from 1984 to 1996 and the Silha Professor from 1990 to 1998. Professor Gilmore passed away this past February and is very much missed. The School of Journalism and Mass Communication, as well as the Silha Center, have launched several initiatives to honor his many contributions to the study of media ethics and law. Please visit the SJMC website or the Silha Center website for further information about upcoming events. And now to the fun part of the evening. It is a genuine thrill for me to introduce tonight's speaker. He is truly a giant in the field of First Amendment law. During his long career as an attorney, Jim Goodale has represented the New York Times in every one of its cases that has gone to the U.S. Supreme Court. He has been innovative, creative, and unwavering in his defense of freedom of the press and the public's right to know. His tireless efforts to expand judicial recognition of the right of journalists to protect their confidential sources has earned him the title, the father of the reporter's privilege. He's a partner in the New York City law firm of Debevoise and Plimpton. He founded the annual Communications Law Seminar sponsored by the Practicing Law Institute in 1973, and through that has been responsible for educating thousands of media lawyers around the country. For many years, he was chairman of the Committee to Protect Journalists, which defends the rights of reporters all over the world. He's a teacher, he's a broadcaster, he's a prolific author. He's a graduate of the University of Chicago Law School and of Yale University. Tonight, Jim will share his experiences and observations about one of the most important First Amendment cases ever decided by the U.S. Supreme Court, New York Times versus United States, informally known as the Pentagon Papers case. What are the lessons of that case, and what do they mean to us today? Jim will be sharing his observations on that with us, and I welcome him. Jim Goodale.
Well, Jane says the fun part for her is to introduce me. I don't know why that'd be so much fun, but I'll tell you, the real fun part for me is to give this lecture tonight, because here I wrote this book about something that happened 1,000 years ago, and all of a sudden, in the last 6 months, all the issues in that case, in a general sense, have come to life, and they've been part of the news cycle. So it makes it very relevant, makes the case very relevant. And I'm pleased to be here, and I want to thank the Silha family particularly for having me. I want to talk tonight about, briefly, I'm not going to spend a lot of time on the Pentagon Papers. It happened so long ago. What the lessons of that case are, and whether President Obama has learned them. Now, Pentagon Papers, what were they? 47-volume history of the United States relations with Vietnam, went back to the 1940s. It was a plain old history that Secretary of Defense, then Secretary of Defense, Robert McNamara, put together with the aid of PhD scholars. Presumably, he never told everybody, so he could learn from the history and avoid the mistakes that were made. It was given to the Rand Corporation. Rand Corporation was an advisor to the United States government, and still is. And at the Rand Corporation, there was Mr. Ellsberg, Daniel Ellsberg. Now, we may have forgotten about the Pentagon Papers, but somehow Daniel Ellsberg is probably known to all of you. He's still around and still talking. And he looked at a copy of the, I don't know which one he looked at. It's 47 volumes. It was sort of like that. But he looked at it, and he really got angry when he saw that the history was a series of lies and so forth and so on since the very beginning, and that the Vietnam War had been built on a tissue of lies. Now, the important part of the Pentagon Papers for you and for the courts was that the Pentagon Papers were classified papers, and they were classified not just secret, they were top secret sensitive. As I point out in my book, the classification was a mistake, but nonetheless they were classified. He effectively gave those volumes to Neil Sheehan, a New York Times reporter, and Neil Sheehan did a series of articles, and the government, United States government, came in and stopped the publication of those articles. And so Mr. Ellsberg, not deterred by that event, gave it to the Washington Post. And so they published a couple of articles, and sure enough, they were stopped. And undeterred by that, Mr. Ellsberg ran all over the United States, and there were a whole bunch of newspapers that published it, but only two were involved in the case called the Pentagon Papers, and that was the New York Times and the Washington Post. The New York Times got stopped in New York, as I said, and then in the lower court, they won, but in the what we call the upper court, which would be the Court of Appeals, the next court up the chain, they lost. And the Washington Post, on the other hand, won below, let's say, the trial court, and then won at the Court of Appellate level. So the two cases came out differently. And that was wonderful for the Supreme Court. The Supreme Court loves to take cases where the two courts differ. So the Supreme Court took the case and came out with this decision called the Pentagon Papers case. Now, what are the lessons of the Pentagon Papers case? I would just say there's a couple that we can think of. Ignore the First Amendment at your peril, and don't buy hook, line, and sinker claims of national security made with respect to any documents that the government has, including, and most particularly, the Pentagon Papers case. The First Amendment issue in the case was, for some reason, when you go back and look at the government papers, not mentioned. I don't think I've seen it once in the government papers, Pentagon Papers, the First Amendment mentioned. And we know what the First Amendment does, don't we? Congress, I'm not going to talk like that. It's like talking to students. But it gives you the right to speak, right? First Amendment, Congress not supposed to stop it. That's what the First Amendment is all about. It doesn't appear in any of the government papers. And instead, what appears is something called the Espionage Act. Now, the Espionage Act was meant for, guess what, espionage. That is to say, I am in the government, and I give information with the intent to harm the United States, and I give it to a foreign power. That's espionage. But espionage is not a leak from somebody in the government to a newspaper with the intent to benefit the public through that leak. And the Espionage Act, therefore, was a peculiar piece of law to pick for this situation where you're trying to stop newspapers from publishing because there wasn't any espionage. And lo and behold, as the case went up the courts, everyone realized the truth of that statement, and the case and the Espionage Act dropped out of the case. And what we were left with was the First Amendment. And the decision in that case is a famous decision, and I say in my book it's a case for the ages because it concluded that unless you can show directly and immediately and irreparably that publication damages national security, then you lose. And the government lost because it could not make that showing. It is a case I do not think will ever be overruled. Now, you might be able to meet that test. It's a hard test to meet, but the case is taken on a mythic quality. It's like, I hate to compare it to Dred Scott, but I'm trying to say it's like cases you've heard about before that have a famous name. Now, President Nixon ignored, I would suggest, at his peril, all the implications of what I've just said, particularly the First Amendment implications. And I would imagine, I bet he wished he never had brought the case, because what happened was when the government tried to try Daniel Ellsberg for leaking, and they tried him under the Espionage Act, a group that Nixon had put together called the Plumbers broke into Ellsberg's psychiatrist's office, and when the judge who was trying him heard about it, he said, the government's got dirty hands, case over. So why is that so significant? Because those plumbers didn't stop breaking in with Ellsberg. They continued and broke into Watergate. And we all know that Watergate was the end of the Nixon presidency. So think of the Pentagon Papers as a case that had the First Amendment in it. Nixon never thought about it. He created a unit that brought him down. Had we not had the Pentagon Papers case, there's an argument that he would never have had to resign the presidency. Don't ignore the First Amendment. If you do, at your peril. Second lesson, do not buy claims of national security made by the government hook, line, and sinker. The reason for that is the government's notorious for overclassification. That is to say, they'll classify anything in sight with a stamp. In fact, I used to do this when I was in intelligence corps and reserves for six months, a weekend warrior, and I used to do that. I had a stamp classified. You know what I was classifying all the time? Copies of the New York Times. It's a true story. And when I got the Pentagon Papers wheeled into my office on with those supermarket things, these 47 volumes, 6,000 pages, and I opened the first one, and I started reading it, and they had footnotes in the back because it's a scholarly document. What did I find there? New York Times. So that's what sort of led me to conclude, hey, this has got to be a bunch of baloney. The government can't come in and put us in jail or stop us for publishing something we've already publishing. Obama, we'll get to Obama down in a few minutes, but Obama, a couple of years ago, classified over 70 million documents. 70 million documents classified, can you believe it? And 4 million people were given access to those 70 plus documents. I would just think, with so many people, with so much access to classified material, every time those 4 million people open their mouth, classified stuff comes out. So how can we have a system that is built this way? It makes no sense whatsoever. And it is run by the intelligence establishment. I don't have much respect for the intelligence establishment because it's a unitary group which does not subject itself to criticism from people like yourself, and they get their own way, and I don't like the way they get their own way because they get their own way through misdeeds and lying. I'm sorry to tell you that's so, but that is a central theme, probably the central theme of my book, to describe the misdeeds that, in the first instance, that the government used to get the courts to come to their side of the case. They would say, if you publish a telegram from Llewellyn Thompson, who was the Russian ambassador, you're going to destroy our relationships with Russia. Not true. If you publish a national intelligence estimate of North Vietnam that's six years old, it's going to be the end of the world. If you say that Australian troops are in Laos, that's going to be very embarrassing, destroy our relationships with Australia. But you know, the government just sort of says this. It's like putting a stamp on it and never tells you why. But when they tell the courts, it scares the hell out of the courts, because the courts don't know whether the government is telling the truth or not. And frankly, it scared the hell out of us, not because we believe what they were saying. We had no chance to respond. Let me tell you give you an example. At the Supreme Court, at 8 o'clock at night, before the argument the next day at 10 o'clock, the government delivered 46 such claims, like the 3 or 4 I've just told you about, and said, you've got to tell us why these don't damage national security by 10 o'clock tomorrow morning. I mean, how do you answer that? I mean, they don't have to prove that it damaged national security. All they have to do is say it damaged national security. And what we have to do is say it doesn't. And the only way you can deal with that is you take a bunch of books and try to find the stuff it's been published before, and that sort of gives a lie. Which leads me to the last point with respect to why you shouldn't buy government claims hook, line, and sinker, and that is they lie. Now, let me tell you what the biggest lie in the Pentagon Papers case. And we have people here from the law school, and I'm going to talk about one of the great deans of law schooldom, Erwin Griswold, who was the dean of Harvard Law School, who became the Solicitor General of the United States and was given this case. The government claimed that the New York Times and others, by publishing the Pentagon Papers, would disclose the fact that the government had broken the North Vietnamese code. Now, you're not all intelligence and analysts, but that's a serious claim. If the government could show that was true and could prove it, I mean, they might have won the case, because that is really big time stuff. Now, let me tell you what they did. They took a piece of paper that had a message from the North Vietnamese, and the message, according to the government, showed, because we had decrypted it, that we knew how to decrypt the North Vietnamese code, and therefore it was published. That would tell the North Vietnamese they would change their code, so forth and so on. They introduced that at the trial court level in the Washington Post case. The judge didn't pay much attention. The case was going so fast, neither did anyone else. Went up to the Court of Appeals, same thing happened. Then, this is the sort of thing the government was doing in the case. And this, by the way, all driven by the National Security Agency, NSA. We know about the NSA? Yeah, I'm going to come back to the NSA, because I'm going to tell you they're doing today just what they did then. They're lying today, too. And so they said, my goodness, let's call up the chief judge, and we'll have a private hearing. Even though they've been through the appellate process, probably more impressive with lawyers than non-lawyers, but you know, you're supposed to go to the trial court, you go to the appellate court, then you go to the Supreme Court. But they said, no, we're not. Then they says, we're not going to follow that procedure. We're going to go have our own. We're going to go see the chief judge. So they go see the chief judge, whose name was Bazelon, and they bring to him what was pretty much like a birthday cake box with a big ribbon around it. And they took off the first ribbon, and they opened the box. And inside was a smaller box of the ribbon. They took off the ribbon of that. And inside there was another box with another ribbon on it. They took about that. And then inside, they pulled out this piece of paper. They said, look, Your Honor, this shows that the North Vietnamese code has been broken. The lawyer for the Washington Post was disturbed. He had thoughtfully brought George Wilson, a reporter from the Washington Post, with him. And George Wilson had brought with him a duffel bag full of reference material. And so the lawyer hands it to George, and he says, George, you better, this one looks bad. And then I talked to George Wilson about a couple of years ago. He had an epiphany. And suddenly in front of his eyes, he knew he'd seen that document someplace before. And not only that, he knew what the page number was. So he went into his duffel bag and he pulled out, guess what, the Congressional record. This is a secret document, remember. It's in the Congressional record. He pulls it out and he gives it to the judge and says the Congressional record, judge says, case closed, is ridiculous. Well, that's not the end of it. The NSA later, when the case is before the Supreme Court, goes and sees of the aforementioned Griswold. Griswold said, what do you think is really bad here? And they hand him the same piece of paper. And they said, give this piece of paper to the Supreme Court because it will tell the Supreme Court that the code has been broken. Now, I think that Griswold knew what Bazelon did. I'm not sure I can totally prove that, but I think he knowingly lied when he gave this piece of paper to the Supreme Court. In any event, the NSA caused Griswold to lie. And so what Griswold did was he gave this piece of paper to the Supreme Court. When did he give it? The argument was at 10 o'clock. He gave it to the court at 9:45 and gave a copy to us. What can we do about it? So the paper went in there, and the Supreme Court was told effectively that the code had been broken, a total lie. So therefore, don't buy this stuff from our intelligence corps, hook, line, and sinker. Push back. You're going to find out if you push back, it's probably not going to be true. And it might even be an intentional lie. Okay, now, we got Obama. Let's apply these two concepts to Obama. Let's do the First Amendment concept first. Don't ignore the First Amendment or ignore it at your peril. Now, Obama has said some strange things about the Espionage Act. He has said, and I've got it in my book, that the espionage, anyone who leaks violates the Espionage Act. Now, how can someone who's a former constitutional law professor say something that's so stupid? Ellsberg wasn't committing espionage when he leaked the Pentagon Papers, and all the other people who have leaked are not committing espionage. They're giving information as whistleblowers, whether you agree with them or not, to the press to publish it. So anyway, that's where he's starting from, and where he's ended up, as you have probably heard, at the time I wrote the book, he had indicted 6 leakers, a world's record. He's now indicted a 7th leaker, and that's Snowden, and we're going to come to Snowden in a few minutes. In the whole history of the United States, there have only been 3, before Obama, there have only been 3 people who have been indicted for leaking. Obama has gone crazy with this, and it has created an atmosphere of fear in Washington, which makes it very difficult for the press to gather and write their stories. I didn't make that up. That was the conclusion of the former editor of the Washington Post, released last week with a Committee to Protect Journalists report saying Obama is very bad on the First Amendment. And Len Downey, who wrote the report, said he's certainly worse than Bush II, and he's coming right up against Nixon. Now, what else has Obama done? He's pursued James Risen. Who is James Risen? Go read your paper today. He's in the paper today. I'll tell you about that in a minute. Risen was given information by one of the 6 people or 7 who had leaked about Iran's nuclear program. And he published that information in a book. The government wanted to know who the source of the leak was. The government, frankly, already knew, but they wanted they wanted Risen to say so. to make a long story short, today, in today's paper, it actually happened yesterday, after 3 courts have looked at it, the case, the Fourth Circuit, that's the circuit in Virginia, said, Mr. Risen, you're going to have to fork it over. And we agree effectively with a lower court that said, anytime someone speaks to you, Mr. Risen, you have witnessed a crime. So just go back to those 70 million documents and the 4 million people. Anytime they talk to anybody, the person to whom they talk is committing a crime. Makes no sense at all. But that's where it stands now. Risen has said he will go to jail when push comes to shove. So we are going to have a situation where President Obama, I think, is going to be in the driver's seat, and he's going to be putting in jail a reporter who reported on information with respect to the Iranian nuclear program, and I would think it stands a good chance of being one big hullabaloo. And by the way, Risen is not just any old reporter. Risen is the one who first broke the NSA story. Now, we think of Snowden as the person who broke the NSA story, but Risen told us all in 2007 about what the government was doing, and he won a Pulitzer Prize for it. So think of Obama is going to be prosecuting the person who first told us about NSA. Not a good position for Obama to be in. Now, the other thing two other things on the First Amendment front that went on at the time, I like to go back to when I published the book, which is April 1st, which were as follows. Reporters want to have their sources protected by a shield law, it's called. And Obama was a big supporter of reporters who wanted to have their sources protected and supported a very good shield law. But when he became president of the United States, he said, I'm only for the shield law if it doesn't apply to people who have national security information. I'm only for the shield law if it doesn't apply to James Risen. A huge hole in it. And he did that because he thought national security was more important than the First Amendment rights of, say, a James Risen. The fourth thing he did, and this is, for me, the most important. I've sort of got 2 purposes in writing the book: to tell you, don't believe the intelligent establishment because they lie and mislead, and I show it, and I want people to be part of that conversation. Second reason I wrote the book is to issue a clarion call to all of you and to reporters that Obama is going to cause a lot of trouble if he prosecutes Julian Assange. Now, Julian Assange is not the most popular person in the world, and he's sort of been out of the news, but not for long. Friday, his movie comes out, right? And so Julian Assange is back in the news. But where has he been? He's been in the Ecuadorian embassy, you may remember, holed up for over a year. And the British government is right outside the embassy. It's costing millions of dollars or pounds for the British government to maintain a guard around the Ecuadorian embassy. As soon as Assange steps out, they're going to grab him. And he's supposed to go to Sweden, but everyone says that that's just a short stop. It's, first stop Sweden, back to the United States. Okay, so what faces Assange back in the United States? There has been a grand jury convened to look into Assange and what he did for the longest time, and it's still alive. I think there's a 50% chance Assange has already been indicted. Okay, you may say, so what? He should be indicted. WikiLeaks is just too much of a bad thing and hardly anything of a good thing. What is WikiLeaks? It's a website that's run by Julian Assange. How did it become prominent? Because Private First Class Manning, who was the leaker, leaked to Assange a whole bunch of documents that Manning had access to. Please note, Manning the leaker, Assange the leakee. Assange is not a leaker. He's the leaky. What did Assange do? He, with advice of counsel probably, I would suggest, he took everything he had and gave it to the New York Times, Spanish paper El País, I don't pronounce it correctly, The Guardian, Il Figaro, and the German paper, which is now, name of which is escaping me. What they did was they edited it and published it. They published, people forget, all those papers published before Assange did. Then what did Assange do? He published what they published. Thereafter, Assange published, and he published some more, and thereafter he let out everything that he was holding within because someone stole his password and they were dribbling it out, so he said, to hell with it, he let everything out. But as lawyers say, ab initio, that means at the beginning, Latin for at the beginning, the Assange website was very much the same, identical to the New York Times. So therefore, if the president prosecutes Assange, it's the same as prosecuting the New York Times. And therefore, if he wins his suit against Assange, it means all publishers everywhere, and by the way, it probably includes all of you, or many of you, because we're all publishers now, right? Many of us have websites. The government can go after people, such as the New York Times or others, and criminally prosecute them. That has never happened before in the history of the country. What happened after the Pentagon Papers case was that Nixon tried to prosecute the New York Times. People have forgotten about that. I have, I think, an informative chapter in my book that describes that ancient history. But he gave up on it after 18 months because it was such a mess. A couple of the people he went after went to the Supreme Court, went on and on. He gave up. I actually tried to figure out why he gave up, and I called one of the lawyers. I said, why did you give up? He slammed the phone down in my face. So we don't know why Nixon gave up, except the important thing is he gave up. Okay, so if Obama succeeds in this prosecution, he will succeed where Nixon has failed. And therefore, I would argue, he's worse than Nixon. Now, when some of the major press read that statement, oh, they loved it, particularly Fox News. And I ended up, if I can brag a little bit, with over 50 interviews on either radio or TV because of that statement. I must say, I'm so impressed with the Twin Cities because I've had such great interviews here. But it all started back then. So I think that's bad enough. But after I wrote the book, it got worse. What happened was a story broke about Associated Press and a subpoena that had been issued to the Associated Press behind the back of Associated Press. There are guidelines that are in place with the government, which say if you're going to subpoena the press to get sources, let them know in advance and have a chance to argue about it. No. Obama's Justice Department went right behind everyone's back and got the information they wanted by going to a telephone company provider and getting all the sources of AP. Well, that was bad enough. Then it turned out they had done something nefarious with respect to a Fox News reporter whose name was Rosen. And Rosen had been talking to a Korean about a Korean source about North Korea's atomic program, and the government wanted the source of Rosen's information, and they said to the court, listen, we can get what we want about Rosen because he's a co-conspirator. Now, wait a minute. Rosen is a criminal? And this was after I said in the book that, look, what does Obama want to do? He wants to criminalize the press. So Fox News got very excited about this, and everyone else did too, that Obama wants to criminalize the press. And so that was bad enough. But guess what? It's not going to get any better, in my humble opinion. One, because I think there's a good chance the Ryzen case is going to be out there before Obama ends his presidency, and I've told you about how I think that's going to break. But there's also sitting out there another case involving a New York Times reporter named David Sanger. David Sanger has information about another Iranian program, and his source apparently is someone named James Cartwright. James Cartwright has been told he's the subject of a grand jury investigation. So I would think there's a good chance that Cartwright's going to get indicted, and then they're going to start chasing Sanger. So I don't see any end in this First Amendment fracas that Obama has stirred up, and I would suggest he's probably ignored, therefore, the First Amendment at his peril. Now, how about the NSA? Okay, let's talk about Snowden. Okay, let me give you my position on Snowden. I think that Snowden has done a public service because, thank you. You know, it's very interesting. I've given my Snowden views to other groups, and there's never been a time when I didn't get some applause for it. I'm really somewhat surprised about that and gratified, actually, because I think it's worthy of applause that he has created a debate that Obama asked for. If we did not have Snowden, we would not have the debate. On the other hand, he is a civil dissident, and a civil dissident has to accept the risks of disobeying the law, which is to face the punishment. I think that Snowden made a big mistake in going to Russia, because if he's a whistleblower, we don't want our whistleblowers protected by Russia. That is just bad, and he should come back and face the music. He did give us information about two programs. Very simply, they are like this. One's a PRISM program that deals with those who call or have internet communication with foreign sources. And secondly, he disclosed a metadata program. It's this latter program that's caused all the controversy. Metadata is a big word, but all it means is information about when you made a call, to whom you made a call, where it was made, and underlying calls that might relate to all of that. It is thought that the government has metadata on all of you, and that the total amount, when you add the underlying calls, comes up to 3 billion pieces of metadata. Now, this program seems to me to be unconstitutional, but what did Obama do as soon as the story broke? He went on Charlie Rose and he said, the program is totally constitutional and no one has abused any of the authority given them. But when in fact we checked, or the press checked with the people who invented the program, one of whom was James Sensenbrenner, who comes from this part of the country, not, I understand, Minnesota, but Wisconsin. He's a conservative who sponsored the Patriot Act. He was upset that the government had taken his program and gone ahead and made it so that it applied to everybody in this room and everywhere else. He said, that is not what I intended. I want to get this program amended. Now, what did the NSA do? Well, the NSA was reacting to two things when this story broke. The first was earlier disclosures by Ryzen. And in this connection, the director of the National Intelligence and Mr. Alexander, who is the head of the NSA, testified before Congress. They were asked, do you have a metadata program? They said, no, we don't have a metadata program. Later, they said they had lied. Alexander said, well, it was the least untruthful statement I could think of. Now, you can see that I have a partisan view with respect to what I've said, and there are other arguments the other way around. I would like to think we would all agree that when a public official lies to Congress under oath, he has to face the consequences. But nothing has happened to Alexander or his peer who runs the DNI. And frankly, I think that's outrageous because the culture of lies and deceit, which I pointed out to you had existed at the time of the Pentagon Papers, and no question about it has continued, becomes part of our culture. We expect our intelligence agencies to lie and deceit to the enemy, but we're not the enemy. And how are our children going to grow up if, in fact, they grow up in a culture of lie and deceit? I used to be a youth hockey coach, believe it or not. And every youth hockey coach, has that session where you put your knee down and the kids come in, they put their knees down, and you try to give them some sense of values. And there's always one kid who's smarter than the others and say, well, how about Alexander, who lied to the NSA or for UNSPA? I mean, how do you answer? How do you answer that? I really think that what they've done is a disgrace, and I think I'm right to get a little bit angry about it. I try not to get angry when I give a talk like this, but this part makes me angry. Okay, so what is Obama going to do now? He's got a program which he's defended, which he says there are no abuses in connection with it. How can he say that when he has two of his officials who lied to Congress? Isn't that an abuse? More to the point, another story broke at about the time of the disclosure of Snowden, that two courts, they're called FISA courts, had NSA lawyers, Justice Department lawyers, appear before them, and those lawyers lied also. In one case, the court said 3 times, and in the second case, 2 times. Now, nothing's happened to those lawyers, so if you want to add up all the lies that we've got here today, we've got the 2 that I've talked to you about, plus the 5 I've just mentioned. There's 7 lies by the NSA, and nobody's doing anything about it. Now, can we expect that Obama will do anything about it? I wouldn't think so. What is he going to do? He's got a program, as I said, he's defended. But now it looks like Congress is going to amend it. So is he going to support that amendment? I mean, he's sort of an embarrassing spot. Now, what we could expect out of Obama is that he would tone everything down, push everything back, and, for example, stop the Rising case from going forward, stop the Assange case from going forward, stop any other cases that he has brought that involve the indictment of leakers, support a shield law that doesn't have a great big gaping hole in it. All of these things Obama could do, and particularly not to bring the Assange case. But I would like to suggest to you, I don't expect Obama to do that. Every instance that I've given you tonight, and every instance I know about, Obama has chosen to favor national security over the First Amendment. But isn't the lesson of the Pentagon Papers case just the reverse? That the First Amendment trumped the national security interest? And so I ask you, has Obama learned that lesson, or has he been hornswoggled and swallowed hook, line, and sinker about national security? I would suggest the latter. President Obama has not learned the lessons of the Pentagon Papers case.
Thank you. As many of you know, it's our custom at the Silha lecture to ask our lecturers to take some questions, and Jim has graciously agreed to take questions from this audience. Now, ground rules. We ask that you raise your hand and a microphone will be brought to you. We've got Brett and Alex with microphones at the back of the room. We would really ask, so that we can get in as many questions as possible, that you keep your question concise and to the point. I know people have very strong feelings about the issues that Jim has raised this evening, but we really would ask you not to resist the urge to make a speech and to ask a question. So with that proviso, if you'd raise your hands, mic will be brought to you.
Just me. Today happens to be the anniversary, October 16th, of one of the largest civil disobedience actions in our country's history. Thousands and thousands of young men on October 16th, 1967, turned in their draft cards. It was during Stop the Draft Week. Given that, and given that you say Mr. Snowden ought to come back and face the music, are you suggesting that he face the music from a government that you said is rampant with a culture of lies and deceit? Are those the people that are going to be playing the music for him?
Answer. Everyone hear me? Answer, yes.
Where'd it go, Simon?
Thank you for coming and for making your presentation. Looking at the second Bush administration and into the Obama era and reading articles on claims of executive power in general, and of course those specifically relating to the First Amendment rights issues of which you spoke, it seems that the national security first mentality is very much what you could call a bipartisan problem in U.S. national security and foreign policy. Given that it seems to be entrenched in both parties' cultures, what way forward do we have to sort of reclaim the First Amendment as a central focus and a central value to be protected?
Well, I think it's a very good point, because I do agree it's a bipartisan issue. There used to be a time when everyone said that all issues and foreign policy were bipartisan. I wish that were still so. But for example, Dianne Feinstein, a Democrat, is probably one of the more hawkish national security types. Now, I think that it is very difficult to get countervailing pressure against the establishment, which I think ought to happen when there are no easy targets in the Senate. So my hope is that the metadata program that Sensenbrenner is now proposing emerges, that there will be some real debate. I hope it gets to the floor. I hope it passes. And we'll start the ball rolling so that both sides of the aisle can see the problems with national security interpretation. That may be naive, but that's my present hope.
There's in the courts, there are so many Republican appointees in the federal courts, and in the Congress, certainly so many critics of Obama. Why, if you, as you suggest, that he's so out of line at this point, why isn't there a pushback on this issue?
Well, I think that there's a whole variety of reasons. I think number one, there are a lot more, at least from a public point of view, important issues than the issues that I'm talking about. Certainly the issue that's before the Congress today as to debt ceiling and so forth and so on is more important. Number two, Obama, for better or for worse, has made Obamacare a very top priority. Three, financial reform, which has sort of disappeared from the front pages, is a priority that has not. Here we are 6 months later, 6 years later rather, locked up. And then I think lastly, civil rights, First Amendment, Fourth Amendment, tend to fall off the map. I think there is an audience for that group, probably the very conservative right and the left, but I don't think it is a huge number, so that if Obama is so inclined politically, he can ignore what's going on. And then lastly, to be cynical about it, there is an argument, or there's a thought inside my head, that the more that Obama can show he's a national security hawk, the better it is for him politically. I don't want to say that that's what he's doing, because I think he's really convinced himself that he's right as to these national security issues, but there is no great political pressure to move him. And so for all those reasons, this issue sort of drops off the map. It will not come back to be a major part of our thinking until some event such as an amendment to the FISA Act or whatever comes up, or I would have thought that if he tries to put Risen in jail or another Times reporter, Sanger in jail, or if his Justice Department tries to do that, and that becomes front page stuff, then it will catch our attention. But otherwise, I think it'll drop off the map.
I'm here. Hello. Reacting to the Assange case, Keller of the New York Times wrote, "Ellsberg needed us, Assange doesn't anymore." And I wanted to sort of turn the conversation for a second to the question of the changing role of journalists, particularly professional journalists, in today's media landscape. The Columbia Journalism Review, in its latest issue, argued that to broaden freedom of expression protections, we should actually abandon, if you will, the definition of particular reporters' privilege or shield laws and expand it for everybody. I tend to agree, in a sense, perhaps with the idea that it's still important to have different type of protections and make the distinctions that you were between leaker and leaky, etc. But I was wondering if you could perhaps elaborate a little from a legal perspective, whether there should be these distinctions regarding professional journalists and random Joe Public or not.
Well, we're in a changing world. All of us are in it. How many people have Twitter? I just got Twitter today. How do we adjust to Facebook? We have, some of us have websites. How do we adjust to the use of a website? It's hard to make a judgment that takes into account these new technological changes and fix that judgment in cement, because it's a fast-moving process. Now, what Congress has done, has been suggested, is that there is a shield law pending that has this big hole in it for national security, but it also just applies to establishment newspapers and leaves out everybody else. And so the question is, as presented, is that right? I don't think it's right. I mean, I think that if we're going to have a shield law that covers journalists, and then it ought to cover those of us who have blogs. It should cover WikiLeaks as a website. It doesn't cover WikiLeaks. And the focus that's in that law presently is rather narrow. Now, there is a provision that lets the court sort of expand the definition if justice determines it. Maybe that's a good solution, but I think that we have people who are, in their 60s or whatever in Congress who are really not part of the digital revolution drafting this law, and the law reflects the old-time distinction between the established press and which has now become the rest of us.
Three-part question on prognosticating from the Verizon case. If Verizon seeks cert from the United States Supreme Court, do you think it will be granted? If it's granted, how do you see the justices falling into line on the question? And how do you see that case affecting the congressional move for a shield law?
Well, I don't expect it, to answer the first part of the question, I don't expect the Supreme Court to take the case, and the reason for that is that they have not taken cases like it in the past. Why don't they take it? It's a very difficult issue. Two, if they do take it, I think it's going to come out badly for the press. And if the case goes back to a point in which somebody says, you tell me, Mr. Verizon, or you're going to the Hooskow, and he goes to the Hooskow, I think people will then say, hey, look at the shield law with a big hole in it. Maybe we should fix that hole. But I'm not optimistic after they look at the hole, they're going to fix it. So those are my three answers.
So, over the course of your speech, it was pretty well established that you have a lot of faith in Obama to mess up what he's doing.
You're going to have to start over again and speak up. I'm sorry, you didn't catch the beginning.
It was pretty well established in your speech that you have a lot of faith in Obama to make a mess of what he's doing as far as the First Amendment and national security go. What behaviors of a future president after him would you like to see to try and fix this disconnect between First Amendment protection and national security?
Right. I mean, I think that a future president should do what Obama should have done on each of these issues. I don't see how Obama can look himself in the mirror when this crisis happened this summer. He appointed some committees, and the committees came up with some new guidelines. They really don't fix the problem. How we can, at the same time, pursue Verizon. So I would hope that a future president, if put in that position, would not pursue Verizon, number one. Number two, would not pursue so many leakers. In a sense, I don't mind a leaker or two, but 7, I mean, it seems it's crazy. It's crazy after a while, and I hope a future president wouldn't do that. I would like to see generally a future president push back. I mean, that's what Obama hasn't done. As I said in my closing moment, Obama, every time when faced with a choice in trying to balance national security and the First Amendment, or indeed the Fourth Amendment, it seems to me every case I can think of, he's always chosen national security. I would hope we would get a president the next time around who's more sophisticated about national security. I think Obama is a very sophisticated person, but I don't think he's particularly sophisticated about national security, and frankly, it's understandable. He's had an academic background. He's not served in the military. He gets overwhelmed probably in meetings by epaulets. You know, I'm always thinking of Obama and 20 epaulets sitting around the table, and he says, hey, I want to cut back on that metadata program. And the epaulets say, well, if you do that, Mr. President, you're going to damage national security. And Obama looks around, he's the only one. What's he going to say? It takes some fortitude to fight back against these guys. But, you know, their only interest is in national security, and that's good. And they've done a good job. I don't want to, you know, we haven't had anything since 9/11. They've done a good job. But you have to push back. You have to have a conversation. You can't have one side have its way all the time. So I hope the new president would not let the national security establishment have their own way all the time.
Any more questions? We've exhausted the topic. Maybe we've exhausted our speaker, although I don't think so. Because Jim Goodale, as you have seen, is a passionate fighter for the First Amendment, for freedom of expression, freedom of the press. Let me now invite you to join us in the atrium in a few minutes, where you can purchase Jim's book, which he's referred to multiple times, Fighting for the Press, the inside story of the Pentagon Papers and other battles, and continue this conversation. We also have comment cards outside on the tables, and we encourage you to fill them out, to be added to our mailing lists, to share your ideas for future Silha activities. And now please join me in thanking Jim Goodale.